All right, Judy. How do we change our parenting time sharing arrangements after the divorce?
Changing your parenting arrangement, your custody plan or order after the divorce. Am I doing this for Connecticut and mediation or otherwise? Should I say it can be done either way or just seek?
You could say.
No, I don't know. Mediation.
No,
I think just attorney.
I think just for attorney. I don't think this works.
Mm-hmm.
You know, if you mediated one, they're just going to come to you anyway.
How do we change a parenting time, a parenting plan?
How do we change our parenting time sharing arrangement after the divorce? I think you should address this for Connecticut.
Okay. Say it again.
How do we change our parenting time sharing arrangement after the divorce?
After the divorce, at the time of divorce, there will be a custody and parenting order in place to follow. If changes and life changes do occur, Say it again.
Sure. How do we change our parenting time sharing arrangements after the divorce?
At the time of divorce, parents will have in place an order of the court that's arrived at as a result of an agreement or a judge's decision that sets out a custodial plan and a parenting arrangement plan for you. As life proceeds and there are changes in life and child schedule, possibly relocation or other issues. No, I'm going too much. I want to say something else. Say it again.
Sure. How do we change our parenting time sharing arrangement after the divorce?
If changes occur to your parenting plan, Okay. At the time of your At the time of divorce, parents will have a custody and parent schedule plan in effect. I said that too slow. At the time of divorce, I have to refocus. I'm getting tired. I want to say too much. I can answer this in like a half a sentence. But I want to draw it out. Say it again.
Sure. How do we change a parenting time sharing arrangement after the divorce?
At the time of divorce, you will have a court order that provides for a custody and parenting plan. As time goes by, there is certain to be adjustments, and parties have to be flexible in accommodating adjustments. Whether a dinner time is changed, a time of pickup is changed, you want to swap weekends. All of these changes are changes made to the original parenting plan. And they don't call for another order necessarily. You can communicate and compromise and continue to negotiate and work within the parameters of what is good for your family. But changes do occur that are significant or that both parties cannot agree upon. And it may mandate, require going back to court to have a modification. And that's referred to as a post-judgment modification. And there are specific grounds and parameters and factors that apply that are specific to your case. Is it a relocation matter that's going to have a significant impact? That is, say, I did it too much. No.
That was going perfect.
I should have stopped it right there.
You could have just stopped it right there.
Yeah. Okay.
So let's nail it on this one. And
okay.
This one is for. So how do you change, or can you change a parenting time sharing arrangement after the divorce?
At the time of your divorce, parents will have a court order that provides for a custody and parenting plan. Certainly, as children grow and situations change, there may be changes occurring, small changes, that both parties can agree to without going back to court and having a contested proceeding or changing the original order. So I encourage you to continue to remain flexible and to communicate as best you can to accommodate the children's and the parents' changing needs. There may come a time, however, that both parties cannot agree to a requested change made by one of the parties, and that may necessitate relitigating and changing, formally changing by a court order, your current plan. This is referred to as a post-judgment modification of the court order. And you should, at this point in time, if that occurs in your life, consult with a competent, skilled family law attorney to look at the factors involved and to see whether you are eligible and the facts of your particular case would render a favorable decision for you if you went back to court.